Well, this is a long-awaited decision affecting public employee unions. The case is Janus versus AFSCME. That's the municipal employees union for state, county, and municipal employees. And the issue here was whether or not those unions can collect mandatory dues even from state employees who are not members of that union. Mark Janus is an Illinois state employee, not a member of AFSCME, objected to the idea that AFSCME was collecting dues from his paycheck on a weekly and monthly basis. So he brought the case to court. The court here deciding ultimately that Mark Janus is right and that a previous Supreme Court precedent, a case known as Abood, will be overturned now. That precedent had allowed those municipal employee unions to collect those what are called agency shop agreement fees. Here's what the court is saying here. They say, we conclude that public sector agency shop agreements violate the First Amendment, and Abood erred in concluding otherwise. Abood was wrongly decided and is now overruled. The judgment of the United States Court of Appeals for the Seventh Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. So that means that a 1977 Supreme Court case that allowed those public sector unions to collect those dues from non-union members has been overturned today by the Supreme Court. So this is a loss for unions and a big win for people like Mark Janus, who decided that they didn't want to participate in the union in their workplace, and they didn't want to pay what amounted to, in Mark Janus's case, $45 a month, Carl. That was the small amount of money, but it's made a big difference here at the Supreme Court today.
Hey there, thanks for checking out CNBC on YouTube. Be sure to subscribe to stay up to date on all of the day's biggest stories. You can also click on any of the videos around me to watch the latest from CNBC. Thanks for watching.